without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Fair enough. As to
Thank you, Your Honor. And just to be clear, we do also reserve all of our objections.
yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those the court will issue body attachment and hold it until the next court date.
And 9.
And 9.
Thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9.
Thank you.
Until the next hearing date. And we'll
Does the court have a list?
It does. The court will seal that list as well.
We've asked
People have a copy or anything?
We've asked that the court seal it specifically because it is ongoing defense investigative data or evidence that we recover and we get, our counsel on behalf of Mr. Reiner gets, and that is discoverable. We'll comply with all, or counsel will comply with all discovery obligations at that time.
Can you address the counsel's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense, and it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
But at this time, the court would just seal it until the next court hearing date.
Thank you.
And how else would Judge proceed?
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they're ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you, Your Honor.
Current counsel turn over any items that they received.
We will absolutely comply with that. We've already begun. The deviation has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery order that's remaining in place for now, and we will serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Preclude me from giving, Mr. Bailey raises a very sage point. I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people, any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you.
So you can provide everything to Ms. Green.
Thank you.
Thank you. Anything further? Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
Good morning. Kimberly Green, here at the Public Defender's Office on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Habib Bailey, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd asked to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine. Court.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take a waiver for you. Entitled, you have a constitutional and statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February the 23rd, 2026. In this department, do you waive your right to be arraigned today so that your matter may be continued to February 23rd, 2026 for arraignment?
Yeah, I agree with that.
Thank you. And is counsel joining that waiver?
I do.
The court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matter set for arraignment in this department, February 23rd, 2026. Bail remains at no bail. Anything further?
No, Your Honor.
Okay, thank you.
Thank you.
Thank you. That's the end of that one. So I'll loop it.
You were just watching. What we just received out of the courtroom here in Los Angeles. Let's bring in NBC News entertainment correspondent Chloe Malas, who can help us make sense of the stepping down of a very high-profile attorney on this case. Chloe, if we have you, I'm sure you were watching that as well, trying to listen to everything that was being said in there. But it seemed as though whatever the reason for Alan Jackson to step down from this case, that was told to the judge potentially in chambers here, but not publicly. What do you make of this?
Gotti, this is incredibly significant and not something that I don't think any of us saw coming today, because now this arraignment is going to be postponed for a third time. We know that when Alan Jackson, when he entered the courtroom, he then had a meeting in chambers. This is behind closed doors with the other attorneys, with the judge. We don't know what was said, but he did say this. He said, "I have no choice but to step down of counsel of record." So as you saw, Nick Reiner will now be represented by a public defender. Her name is Kimberly Green. So this arraignment now being moved to February 23rd. So now this is being delayed a second time here. And, you know, we were wondering if Nick Reiner was going to enter a plea, and he has not yet. And at the center of all of this, Gotti, and you've been on the ground doing some really great reporting here, is, you know, his mental health really being called into question. We know that he is not on suicide watch. Nick Reiner, NBC News, had learned that that had been removed yesterday, that he was not going to be wearing the smock that he had been wearing before. And so previously, we know that Alan Jackson had said that he needed more mental health evaluations for Nick Reiner. He said that they were procedural. We don't know exactly what they were evaluating. But again, that is something that will potentially come up at the next arraignment, depending on how he pleads.
Chloe Malas, thank you so much. Let's bring in NBC News legal analyst Danny Savalos. He's also a criminal defense attorney. Danny, one other thing that struck me was hearing Nick Reiner. We didn't see a video of him, but we heard Nick Reiner saying that he waived his right to a speedy arraignment here when they were asking him if he was okay with the date in February. But again, to what Chloe was just talking about, when it comes to his mental state, we only have that sentence that he said to judge where he stands right now and in his mental state, which is almost nothing. But that is going to play such a big role in this case, regardless of what we see going forward, right?
We can't gauge anything from the few words he says in court, nor can we gauge anything from the photographs and the podcasts that he may have appeared on. The bottom line is this, is that his defense counsel, whether it was Alan Jackson or the public defender now, has to consider the possibility of a not guilty by reason of insanity. But here's the thing. In California, the mere fact that you may have been using drugs and alcohol does not create an insanity defense. The mere fact that you may have been temporarily under the influence of drugs is not sufficient for an insanity defense. So this is something, by the way, and the mere fact that you have mental illness does not automatically mean you have the insanity defense. So this is a very difficult decision. Whether or not the defendant wanted another continuance of the arraignment, it is critical to decide how they want to enter a plea and whether they want to enter a plea of not guilty or not guilty by reason of insanity or both.
A complex case that just got even more complicated. I also want to bring in NBC News legal analyst Misty Maris. Misty, when it comes to some of the different options that are now in front of a potential public defender here, but possibly some other counsel that steps in, what are the options that Reiner has?
So there are many reasons why this public defender said, I need more time in order to assess next steps before entering a plea. And that's because an assessment has to be made on several issues. One, looking at Reiner's mental state right now, is there a need to have a competency proceeding? Meaning, does an expert need to step in and weigh whether or not Reiner understands the nature of the charges against him and can participate in his own defense? That's looking at his mental state at this moment during these proceedings. Also, they have to think about whether or not they're going to enter a not guilty plea, not guilty by reason of insanity, try and work with prosecutors to engage in some other plea conversations, All of that is going back in time and looking at Reiner's mental state at the time the murders occurred. We don't know where the defense is going to go, but the first step is to get as much information from a defense perspective, mental state evidence, to make that assessment and to ultimately determine how to defend this case.
Yeah, and that public defender may be starting from square one at this point. Misty Maris, thank you so much.